Today's question is, am I, as an 11-year-old, allowed to go to court in a situation where my parents are divorced to see if I can get my dad to have full custody of me, even though my mom doesn't abuse me? This is a great question. I'm going to answer one aspect of it. I can't speak for all jurisdictions, but I can tell you that 1, what the law is for the state of Utah, and 2, what, in my experience, actually happens when a child wants to be heard on the subject of his or her desires regarding the child custody award. The law for the state of Utah provides that a child can testify as to the child's preferences regarding the child custody award if the court allows the child to testify. Specifically, Utah Code Section 30-3-10, Subsection 5 applies. That subsection provides, quote, a child may not be required by either party to testify unless the trier of fact determines that extenuating circumstances exist that would necessitate the testimony of the child be heard, and there is no other reasonable method to present the child's testimony, close quote. It further provides, quote, the court may inquire of the child's and take into consideration the child's desires regarding future custody or parent time schedules, but the expressed desires of the child are not controlling and the court may determine the child's custody or parent time otherwise, close quote. Subsection 5 also provides that the desires of a child 14 years of age or older shall be given extra weight. They don't decide it, folks, that's a myth. But it is not the single controlling factor of a 14-year-old child if an interview with a child is conducted by the court. If an interview is conducted pursuant to subsection 5, the interview shall be conducted by the judge in camera and on the record. Finally, subsection 5 provides, quote, the prior consent of the parties may be obtained but is not necessary if the court finds that an interview with a child is the only method to ascertain the child's desires regarding custody. So what do these words actually mean? How does 33-10 work, or how should it work? Well, get ready to be confused and upset. Section 30-3-10 provides that a child can testify, but only under circumstances that most Utah courts construe so restrictively as to make it all but impossible for a child to testify. How? Most Utah courts will say, I know this because I'm one of the few attorneys who thinks children are smart enough and emotionally tough enough to testify intelligibly and should be heard on the subject of the child custody award when they want to be heard. So here's what courts do. They'll say, 1, the extenuating circumstances that would necessitate the testimony of the child do not exist, and will, if the court has anything to say about it, essentially never exist under any circumstances. 2, the court will say there's always another, quote, reasonable method, close quote, to present the child's testimony without actually presenting the child's testimony directly from the child's mouth to the judge's ear. Generally, courts in Utah will bend over backward to avoid hearing from the child directly, even a child that they know wants to testify. Also, other reasonable method means ensuring that the questions posed to the child on the subject of child custody by someone other than the judge, go figure, are not recorded, that the child's purported answers are not recorded also, and that the child's testimony is then filtered through and summarized by a third party, such as a guardian ad litem and or a custody evaluator. As if to say, well, asking the questions through a guardian or a custody evaluator is somehow less traumatic, as if it was traumatic in the first place, than a court judge actually doing it. If a court in Utah has ever found, quote, an interview with a child is the only method to ascertain the child's desires regarding custody, I'm not aware of any such case. What is so frustrating to me is why would such a law exist? Why isn't the law just the opposite? i.e., unless the evidence shows that the judge interviewing the child will not ascertain or at least help the court to ascertain the child's desires regarding custody, the court shall interview the child to ascertain the child's desires regarding custody. Why not that?